Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University.
Welcome back to Civics in a Year. Today's guest is Professor Sarah Mayeux, a legal historian at Vanderbilt University, whose work illuminates how America's criminal justice system came to be. She teaches and she writes on criminal law, criminal procedure, and the history behind the institutions we rely on today. She is the author of Free Justice, A History of the Public Defender in the 20th Century America, a book that traces the origins of the public defender system and its impact on access to justice. I am beyond delighted to welcome Professor Sarah Mayeux to the show. Professor, thank you so much for being here. Today we're talking about Gideon versus Wainwright. So Gideon is often described as a landmark case in expanding the right to counsel. From a historian's perspective, what were the legal and social forces that made the court receptive to Gideon's claims in 1963?
Great. Well, thanks so much for having me. And I'm excited to talk about this subject, which I've been thinking about for a long time. So Gideon versus Wainwright is, as you noted, a landmark Supreme Court decision that was decided by the Warren Court, meaning under the leadership of Chief Justice Earl Warren, who was the head of the Supreme Court during the 1950s and 60s. And Gideon was decided in 1963, and it held that if you are charged with a crime and you cannot afford to hire your own lawyer, that the state has a constitutional obligation because of the Sixth Amendment right to counsel to actually provide you with a lawyer free of charge that will represent you throughout that process. And so by the time the court decided Gideon, there were a number of both long-term and short-term factors that made this decision seem like the correct one to the Supreme Court at that time. So gradually, for many decades, by the time the court gets to Gideon, the Supreme Court had already been expanding the right to counsel in certain types of cases. As early as the 1930s, the Supreme Court had held that in a death penalty case, for example, it was important for the state to make sure that there was adequate time to prepare for the trial and that there was meaningful representation by counsel. The Supreme Court had held also in the 1930s that in federal court, if you're charged with a federal crime, that the federal government already had an obligation to appoint counsel in federal criminal trials. So Gideon expands that to state criminal trials, which is important because that's where the majority of all criminal prosecutions take place, is in state level courts. But so Gideon, in a way, is expanding on things that the court has already held in earlier cases. But those earlier cases always said you have a right to appointed counsel in, if the case is particularly serious or it presents special circumstances. Whereas Gideon just makes an across-the-board rule that basically any kind of serious felony criminal trial requires a defense lawyer to assist the defendant. And so in one way, you could say this is something we often see, which is the law is gradually expanding over time. What also happens by the early 1960s was this context, what I write about in my book on the subject, the Cold War context. So I think that's also important for explaining Gideon. It's a moment when the United States is trying to distinguish itself in a variety of ways from the Soviet Union and from totalitarian regimes more generally. And there is this sense culturally and politically in the United States that one thing that distinguishes American democracy from alternative methods of setting up society at that time is this commitment to individual rights and fair treatment by the government and protection of the individual. And so although you can't draw a direct line proving that this caused Gideon to be decided when it was, there is a lot of rhetoric in the Gideon opinion that invokes this sense of national identity, justice, Black rights in the opinion. The right to counsel may not be fundamental in some countries, but it is in ours. So there's this sense that a government obligation to protect individual rights in criminal trials where the government's power is at its apex and the individual is especially vulnerable, that becomes central, at least rhetorically, in cases like Gideon to this defense of American identity during the Cold War. So that's kind of that's a bigger picture piece of historical context that I think helps to explain the decision.
That's so interesting. I never thought of it through that lens. So your work traces the evolution of the public defender system. How did Gideon change the landscape for public defense in practice, not just theory? And what challenges emerged as states tried to implement this ruling?
Right. So the interesting thing about Gideon is that it actually doesn't say the words public defender per se. It's not directly about whether states have to have an office that they call the office of the public defender or how exactly they have to set it up. So all Gideon says is every defendant has a constitutional right to state-provided counsel. The state, therefore, or the local government, if they want to set it up as a local responsibility within the state, but the government basically has the obligation to figure out institutionally, well, how is our state going to meet that constitutional obligation? And so by the time Gideon comes along, there already were some states that had very well-established public defender systems. California is an example that actually, even before it was a constitutional requirement, they had established public defender offices in Los Angeles and San Francisco and some other parts of California going back to the 1910s and the 1920s. And they had just set up those offices because they thought it was a good idea as a matter of public policy and local government, not because it was a constitutional requirement. But after Gideon, of course, those public defender offices also now fulfill the constitutional requirement as well. And so if you were a state that already had public defender offices in place, like California, then Gideon wasn't so much of an institutional challenge. But in a lot of other parts of the country, there was no history yet of institutional public defender offices. So in the Northeast, on the East Coast, there were a number of private organizations that were similar to what we might call a legal aid society today, but they provided criminal defense in some cases to criminal defendants, but it was sort of on a volunteer basis where the lawyers were getting paid, if they were getting paid at all, through private donations, kind of the way that you might give to charity that you support in your community. And so they were generally smaller operations because they didn't have government funding and they were operating on the basis of private donations. There also were parts of the country that really didn't have anything in place at all before Gideon that were appointing individual lawyers case by case in death penalty cases or other serious cases, but otherwise we're just kind of relying on individual lawyers in private practice on an ad hoc basis to help out with indigent criminal defense. And they didn't have any kind of organization, much less any government office that was in charge of managing this. So after Gideon is decided, all the states have to figure out something to do because otherwise then they're not going to be able to convict people in criminal court in a way that will stand up on appeal if they haven't been providing defense counsel. So in a lot of states that had private organizations like legal aid society type programs, what they eventually do is keep those private organizations are in place, but start appropriating government funding to those organizations. So they kind of become quasi-public defenders, even if they technically are established under private auspices. They're now getting not huge amounts, I should say, but they're now getting amounts of government funding, huge in contrast to zero, which is what they were getting before, although still not maybe adequate to the need. So one thing you see is the expansion of the public defender model in the sense of taking what had previously been private sector efforts to provide criminal defense and then transforming them into more of a public entity, or at least a publicly funded entity. There are efforts to just establish new public defender offices from scratch in places that didn't yet have a public defender office. And in some places, those efforts work out. In a lot of places, they experiment for a few years and maybe the efforts are not totally permanent or sustainable. One difficulty of implementing the Gideon decision is, again, that it's not a decision that really gives any guidance about nuts and bolts questions of how do local and state governments actually implement this, because the Supreme Court was looking at this from the perspective of the individual criminal defendant in every case needs to have a lawyer. But if you're looking at this from a policymaking perspective and you're thinking about, well, there's 10,000 criminal defendants a year, or however many there might be, and so who is supposed to be paying for providing lawyers across all of those cases, that becomes a much more complex policy problem. And the constitutional doctrine doesn't really address those questions. So after Gideon opened up this era of basically political and administrative debates and efforts, kind of trying to figure out how exactly to implement this right.
So 60 years later, the promise of Gideon still seems uneven. Where do you see the biggest gaps between the constitutional right the court recognized and the realities of the indigent defense today?
Well, unfortunately, what I found is that shortly after Gideon, by the 1970s, just 10 years after Gideon, there were already a lot of lawyers and journalists who were complaining that there was a crisis in indigent defense, that public defenders didn't have enough funding, that they were overburdened, that the promise of Gideon was not being fulfilled in practice in every criminal case. And unfortunately, you see those same articles about a crisis in indigent defense in the 1980s, the 1990s, certainly the 2000s, into now we're in the 2020s. And every so often, I still open the newspaper or the New York Times or whatever is your news source of choice. And there are always these exposés about some public defender office somewhere in the country where the funding is inadequate and the lawyers are trying to somehow represent, 200 people at a time. And so it's not really providing the full individualized adversarial defense representation that Gideon envisioned. So in one sense, you could say that Gideon has been a kind of failed or a muted promise is often the language that law professors use. I actually don't know that I wouldn't describe Gideon as a failed promise myself, because I do think it spurred a lot of change in the sense of, there are places that have a public defender at all today that might not have without Gideon. There are certainly places that expanded the investment they were making in this. There are a lot of law students today that come to law school wanting to become public defenders. And I know a lot of public defenders who, of course, work very hard and do provide, excellent representation in their cases. And there are some offices that are better funded than others. And there are some places where I think, this promise is working out, obviously not perfectly because you're trying to provide a service to large numbers of people who are in very difficult situations by definition. But I wouldn't necessarily call it a total failure. But I do think that the difficulties and the inequities of the implementation and the fact that there are some places where you would say there really is very little and maybe no meaningful defense representation being provided at all if you're in rural areas or areas where just the mechanisms for funding indigent defense were never fully worked out in an adequate way. I think that these challenges highlight the limitations of constitutional law on its own to provide fairness and equality and justice and all of the other aspirations that we have. So I think constitutional rights are very important. And obviously, to have the Supreme Court affirm that something is a requirement, a minimum obligation of a fair and just society to provide is a very important piece of aspiring for justice. But there's this whole other side of it always, which is implementation. And that is much more a question for the political process. And so I think in a way, Gideon and its troubled implementation highlights the importance of constitutional law, but also that constitutional law alone is not enough to fully guarantee the values that we seek to uphold in our society. And so people need to also get involved in efforts at the local level, lobbying, paying attention to how is the state legislature appropriating funds, state level budgetary decisions, even more granular administrative and bureaucratic decisions about how is the public defender appointed or what are the salary scales for, lawyers in this particular county or something like that. So it's at those levels that a lot of the actual practical details get worked out. And the constitutional law hasn't really had so much to say about that. So that's really up to people and their political representatives to try to address.
Professor Mayeux, thank you so much for joining us today. Your historical insight and clarity help us see Gideon and our criminal justice system really with fresh eyes. We're so grateful for your time and for the important work that you do.
Well, thanks very much for having me.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.